You're on live? Go ahead. Good evening to all of you. We continue from where we have left yesterday. We were dealing with the malpractice insurance. Here, again to recap malpractice insurance, here, uh, as far as malpractice insurance means, where an employee is employed and he deals with cash and financial transactions, he is insured against any malpractices committed by him or any embezzlement or misappropriation or breach of trust or cheating committed by him, and the insurance premium is paid by the employer to the insurance company. And in case of any embezzlement or breach of trust or misappropriation, the policy is invoked and the amount is claimed from the insurance company. But after that, the insurance company and bank join together, bring an action against the delinquent employee, and then recover that money which the insurance company has paid. And this, in law, no doubt is a form of indemnity, but it is what is called subrogation. That is, the insurance company gets substituted in the place of the bank and then recover that money what it has paid to the bank uh, in view of the malpractice committed by the employee. And this was mostly prevalent in the State Bank of Hyderabad, erstwhile State Bank of Hyderabad, before amalgamation with State Bank of India. And I told you also they had a unique type of insurance called fidelity insurance. They used to insure the employee who deals with cash, and in case of any malpractice committed by him, they pay the premium every year, and that amount is paid by the policy is invoked, and the insurance company makes good the loss. Then the insurance company gets substituted in the place of the bank, and the bank and the insurance company join together can bring a suit for subrogation and then claim back that amount which has been paid due to the dereliction of duty by the cash officer. That was called fidelity insurance. Here, there is one case is on this particular point. The case is, please do note down, Secretary of State versus Bank of India. Secretary of State versus Bank of India. In this case, what happened was a broker was in possession of a government promissory note, endorsed it to the bank with a forced endorsement. The bank, in good faith, applied for uh, and got it renewed from the public debt office. Meanwhile, the owner sued the Secretary of State for conversion, who in turn sued the bank in an implied indemnity. It was held that it is general principle of law that where an act is done by a person at the request of the another, which act is not itself manifestly tortious to the knowledge of the person doing it, and the act turns out to be injurious to the rights of a third person, the person doing it is entitled to an indemnity who requested him that it should be done. Here, in this particular case, what happened was a broker, what he did was he was in possession of a government promissory note executed by the government, and then he endorsed it in favor of the bank, that is Bank of India, with forced endorsement. He forced the signatures also. Then the bank, in good faith, acted in good faith and got it renewed from the public debt office. Then, meanwhile, the person who was the actual owner of that particular promissory note sued the Secretary of State for conversion. He contended, saying that the Secretary of State has converted forced the promissory note, which does not belong to the person who endorsed it in favor of the bank and got it renewed from the public debt office. So the bank has to compensate him as far as the loss sustained. Then, in this case, what happened was the bank acted in good faith, had an impression that it was a genuine document, got it renewed from the public debt office, and then the bank was asked to make the payment to the Secretary of State was asked to make the payment to the person who was the true owner. Then subsequently, what happened was Secretary of State brought an action against the Bank of India and then wanted to recover that money which has been paid. In this case, it was said it is an implied contract of indemnity where the bank has to compensate the person who has paid the money for and on behalf of the person who has endorsed the terms and note. So a contract of India, of course, this case is not very, very important. But by the way, since it was referred, I have referred that particular case. Then coming to our leading case on this aspect, which is an authority on the law of indemnity, that's the case of Dugdale versus Loring. Dugdale, D-U-G-D-A-L-E, Dugdale, D-U-G DALE versus lowering, LOVERING, Dugdale versus lowering. Dugdale versus lowering. Here in this case, what happened was a person where one person wants another to execute an act that is not plainly tortious or unlawful. The latter agrees and the conduct injures the rights of the third party, the performing party is entitled for indemnity by the asking party. Here, a person wants another to uh, execute an act that is plainly tortious or unlawful. Here, one person is authorized to by another person to do an act which is injurious, which is tortious, or which affects the rights of people. Then in the latter and the conduct among the injures the rights of a third party because of the instructions given, because of the directions given, the person acts on behalf of another and does an act which is not plainly tortious or unlawful. It is not tortious. Tortious means it's not a civil wrong or it is not unlawful. Then the latter agrees and the conduct injures the rights of a third party. Here, A, I can put it in the form of an illustration. A authorizes B to do an act or to execute an act or to perform an act which is not injurious, which is not tortious, or which is not unlawful. Then A, believing the words of B, acts on it and does the act, and it which in turn injures the rights of a third person. Then the third person brings an action against the person doing it and then claims the money. And here A is compelled to make good the payment because of the wrong directions. Here, since A has paid the money without any fault of his, and that the third person whose rights are injured is compensated, then in that case, whatever money he has paid, he is entitled to get it back from the person who gave an assurance or gave him directions to do an act. Here, sometimes what happens is, for time, here sometimes please remember we are not that conscious in Telangana or Andhra, but in Karnataka, what happens is if a premises is let out and you are a tenant, what the landlord does is first and foremost is he takes a lease deed or he takes a rental agreement from you. And in the rental agreement, all the terms and conditions are imposed, all the terms and conditions are mentioned, and it comprises of two parts. One is called Schedule A and other is called Schedule B. Schedule A contains what is called the description of the property, the number of rooms in the property, the number of doors in the property, number of fixtures in the property, so on and so forth, and the extent of the land or extent of the property that has been let out to you. Then Schedule B will contain what is called the fixtures and fittings which are available in the tenanted premises, or the color of the wall, color of the wash basin, color of the toilet seat, and fixtures and fittings like fans, air conditioners, so on and so forth. The understanding is that in case you vacate or in case you try to get out of the premises and go to another property, and if any damage is caused to it due to negligence, then in that case the or it is destroyed by fire or it is destroyed by natural calamities, and the contract and here it is said that whatever loss has been caused will have to be indemnified by the person concerned who is in occupation of the property. Please remember, in Karnataka, they're very, very strict about it. They say, I've given you the walls with grey color. You have to put that grey color and then give it. Then, if the toilet seat is blue in color, same blue color has to be replaced in case it is broken. In case the wash basin is broken, the same color in which that wash basin was there at the time when it was let out, you will have to give it in the same condition. So that is a strict law as far as Karnataka is concerned. But here we are almost tolerant to everything. When we take possession of the property, you remember how much of damage is caused. The glass panes are broken, the washers go, the pipes are removed, tube lights are removed, then the fans are removed, electricity bills are not paid, water bills are not paid, maintenance is not paid. All these things we are oblivious about it, and we don't bother about it because the question is how to find where this tenant has gone. And sometimes he leaves a big burden to you. And when you take possession of the property, nearly 30,000 or 40,000 rupees, you will have to spend it to bring it to shape. So these are the things which are prevalent in our Telangana and Andhra area. We are not that particular about these fixtures and fittings. But in Karnataka, everything has to be restored back in the same position as it was when it was let out to you. Then the principle of indemnity is that it is an insurance contract where any damage, any loss or injury caused only to the extent of loss incurred, and the insurance contract ensures that the insurer does not make a profit in the to the uh, extent of the damage. Here it is said, as far as the damage is concerned, as far as the destruction is concerned, as far as the deterioration is concerned, or as far as the loss of goods are concerned, which are insured, the appraisal has to be made, the extent of damage has to be ascertained, and only when it is ascertained, the question of compensation comes. But the principle of indemnity says when you insure your house, insure your shop, insure your articles, then the insurance company's liability is absolutely absolute and they have to compensate you. But not to that extent what you ask. But the question is, it has to be appraised, it has to be estimated, and only after estimate and other considerations are taken, your compensation amount is paid. The leading case on that aspect is one Jetalal, a Marwadi, a businessman having an electronic shop. He insured the electronic shop for worth 10 lakhs, and part of it is destroyed by fire. He claimed 10 lakhs, but on appraisal, loss was estimated at 2 lakhs, and therefore only 2 lakhs can be paid. Here, suppose let us say one businessman insures this shop. He has got an electronic shop, and the worth of the goods there is 10 lakhs, and then he insured it and then paid the premium regularly. And then he brought an action against the insurance company claiming a sum of rupees 10 lakhs towards the destruction of some of the items. Then the insurance company entered upon the appraisal and found that only 2 lakhs loss was sustained and not 10 lakhs. And in this case, what the court did was they awarded only 2 lakhs as compensation and not 10 lakhs as claimed by the person concerned. Then if you have a car, here suppose let us say it also happens. So suppose I have purchased a car, a second-hand car, which is about 5 years old, and the car unfortunately meets with an accident, and there is damage caused to the car, and I insure the car, and I take a comprehensive insurance against any damage caused to the vehicle. Then what happens is, then I make an insurance claim, and when I make the insurance claim, the insurance company carries out an appraisal, carries out the extent of damage that is caused, and then also deducts the depreciation value because the car is already 5 years old, and then accordingly the compensation is fixed, but not the amount what you claim from the insurance company. Here, the functions is the object of the user is to put back then what is the object of indemnity, sir? Why indemnity should be there? See, after all, what you should not lose in your life, what damage you should not sustain, what deterioration you should not suffer, what the goods which are there in proper order are destroyed beyond redemption, and then you cannot use those goods. And the aim or the object of indemnity is that to see that you are put back in the same position which you were prior to the destruction being caused. That is the main aim and object of the law of indemnity. That is to compensate you or to make good the loss or to put you back into the same position which you were there prior to the destruction. And it is also said that uh, here, the second one is that you are compensated after full inspection and calculation of the loss. It is a matter. It's more or less than the. This is that is you do not get profited. Please remember, in the name of insurance, in the name of getting compensation, you cannot make an inflated claim. Please remember, once you invoke the policy and then claim an amount or compensation are based on the indemnity from the insurance company. First, the insurance company comes, finds out the cause of the accident, how much damage has been caused, how much amount it is likely to cost you in case you have to put it back in the same position which it was prior to the accident being committed. So all these things will have to be gone into the extent of damage, the estimated damage, the damage claim, and also the actual damage which is awardable only after appraisal, only after inspection, only after inquiry, only after a thorough inquiry, looking into all the documents and the causes of the accident. All these are, or whether you have been negligent, whether you have been not, you are the wrongdoer. All these factors will be considered at the time of payment of compensation. But one thing you remember, suppose you have an insurance policy on your vehicle, and when you have an insurance policy on your vehicle, whatever loss is cost you, the insurance company makes good that loss in case you invoke the policy. But if you do not claim any loss from the insurance company, every year what happens is, from the premium which is liable to be paid by you, the bonus is given to you and the amount is deducted, and you pay a lesser amount than what you have to pay as far as the policy amount is concerned. Then survival benefit. Next one is survival benefit. That means the amount that you would receive in case you survive the policy duration. It is mostly present for whole life. Please remember, I told you insurance policies are of two types. One is called endowment policy, and another is called life policy. As far as endowment policy is concerned, it is taken for a specified term, 10 years or 15 years or 20 years, as the case may be. Once the 10 years or 15 years or 20 years comes to an end, the maturity amount, along with the accumulated interest or bonus, is paid to you, not before that. But of course, you can pledge it and then you can raise loans also on the basis of the policy. But as far as comprehensive is concerned, the entire amount is paid. But one thing is this, the question is, in life policies, it is normally issued for 100 years. Please remember, whether we live for 100 years or not, no one knows. But it is payable to your survivors. After your death, your dependents get that amount. So normally, no one prefers a life policy because everyone wants money immediately. So the question is, life policy is concerned, the premium that is paid is lesser than what you pay for an endowment policy. But life policy doesn't become payable unless and until your life comes to an end. And normally it is computed as a period of 100 years, which is taken for the purpose of computing the compensation. Here, one of the leading cases on indemnity is United Commercial Bank versus Bank of India. That is reported in AR 1981, sir. United Commercial Bank versus Bank of India. Here, courts held that the courts should not grant what is called grant injunctions restraining the performance of contractual obligations arising out of the letter of credit or bank guarantee if the terms of the conditions have been fulfilled. LOCs or letter of credit or bank guarantee imposes absolute obligations to pay. Here, Bank guarantees are given, sir. Why? Bank guarantees are in the form of a credit note. Suppose, let us say, there is a court case pending, a money suit is filed against you. Then your banker is prepared to give you bank guarantee, or the amount which is due, which is ultimately due and payable under that suit. The banker undertakes to make good that payment and then guarantees the payment for and on behalf of the customer. But please remember, the bank does not give you a bank guarantee for an unlimited period. It gives you for 1 year or 2 years to the credit of the suit. But in turn, what the banker does is he says that you please give me a fixed deposit for 30 lakhs or 50 lakhs. The bank in turn gets the fixed deposit, gets its business, and in turn, commensurate with the deposit which has been made into the bank says, in case you do not pay, we will pay the money and we will guarantee the payment and we will stand guarantee or we will indemnify the person concerned for and on behalf of our customer. This is normally called the letter of credit, or it is also called a bank guarantee. And bank guarantee is not given for unlimited period. It is given for a limited period or on some considerations. In this case, what happened was the court should not grant injunctions restraining the performance of contractual obligations arising out of the letter of credit or bank guarantee if the terms and conditions have been fulfilled. Letter of credits or bank guarantee impose absolute obligations to pay. So, as far as the insurance company is concerned, as far as the bank is concerned, once a letter of credit is given, once a bank guarantee is given, the question is they have to pay. But in the same way, as far as the contractual obligations are concerned, a party should not be restrained from performing his contractual obligations. He should not be prevented from keeping up his promise. In case he is negligent, in case he is not diligent, then the question is the liability of the indemnifier does not come. But in other words, as far as the liability of the insurer is concerned, when all the terms and conditions have been fulfilled, when all the obligations have been performed, then in that case, the insurer is absolutely liable to indemnify the person who has suffered a loss. Then one more case which is decided is the Calcutta case, Rohit Kumar Saha. Rohit, R-O-H-I-T, Rohit Kumar, Kumar, Saha, SAHA versus New India Assurance Company Limited. This is reported in AR 1997, Calcutta. A indemnifier must pay the full amount of the value of the vehicle lost due to theft as given by the surveyor. Any lesser value is violation of Article 14 of the Constitution. Here the question is, when you insure a vehicle, you insure for the entire cost. The premium which you pay in respect of an insurance policy in case of loss, in case of theft, in case of destruction, in case of damage, in case of, let us say, the vehicle not being traced. Then in that case, the insurance company has to pay the full value of the vehicle and they cannot budge or they cannot bargain and say, we'll pay you 60%, we'll pay you 70%, or we'll pay you 80%. In this Rohit Kumar's case, the insurance company was made liable to pay the entire cost of the vehicle which was lost due to theft. But there are certain precautions to be taken. Once you lose your vehicle, once there's a theft of your vehicle, it is incumbent upon you to lodge an FIR with the concerned police station, then wait for a statutory period of 3 months, and then the police has to give you a report saying that the vehicle is untraceable, and we have made our best efforts to trace the vehicle. In spite of our best efforts, the vehicle cannot be retrieved, vehicle cannot be restored. Then in that case, the insurance company's liability is to pay the full value of the vehicle, provided you submit them the FIR, the first information report, as well as the Panchanama, which is conducted, wait for a period of 3 months, and then alone you are entitled for the value of the full vehicle. The insurance company's liability is absolute. They cannot deduct any amount from the compensation that is liable to be paid. Then, when does the commencement of indemnity start? It says, unless indemnity holder suffers loss, he cannot make the indemnifier liable. So when does the consequences of indemnity follow, sir? you must suffer an actual, you must have a vehicle, or you must have a property, and you must actually suffer a loss, or you must suffer a damage, or you must suffer a destruction. Unless that event happens, unless that contingency arises, you are not entitled to claim any compensation. Is it clear to you, please? Unless there's an actual loss, unless there's an actual damage, unless there's an actual destruction, and that destruction cannot be retrieved, then alone the question of invoking the indemnity clause arises. If not, no indemnity can be done. The leading case on that aspect is the case of Gajanan Murashwar, Gajanan, Gajanan, Gajanan Moreshwar, Moreshwar, Moreshwar versus Moreshwar, Moreshwar Madan, Moreshwar Madan. That is Gajanan Moreshwar versus Moreshwar Madan. This was decided in 1942 by the Bombay High Court. It was in a contract of indemnity held very little value of the indemnity holder could not enforce his indemnity until he actually paid the loss. If a suit was filed against him and he had to wait till the judgment and pay the damages upfront before suing the indemnifier, he may not be able to pay the judgment fees, and could not sue the indemnifier. Here it is said that it's held that here, if his liability has been absolute, he was entitled to get the indemnifier to pay the amount. Sometimes what happens is the court delays are there, sir. No one can blame for it. The case takes a long time for being disposed of. In the meanwhile, the other side is pressing you for payment, and a decree is also passed. A decree is likely to be passed against you, and you will be compelled to pay the amount what is claimed towards damages. And sometimes you may not have the money to pay, though you have taken the insurance policy, or there's a clause of indemnity where the insurance company or someone tries to indemnify your loss, and please remember the other side will not wait for it, but you are compelled to pay that money, not only the money which has been awarded, also the interest part of it, the cost part of it, etc. Then in that particular case, the insurance company has to indemnify the indemnity holder immediately so that he gets out of the debt. So this is as far as the contract of indemnity is concerned. Just a minute, sir. No doubt, the contract of indemnity is a very small chapter. It consists of only three sections, 124 to 126. And as far as possible, I tried to amplify those three sections and decorated it with case law wherever possible, illustrations wherever possible, or the significance of indemnity, the significance of an insurance contract, or the circumstances under which the indemnity holder is entitled for compensation, or the conditions that are imposed as far as grant of compensation is concerned, or how the appraisal is done. How, suppose you ask for an inflated claim, whether the inflated claims can be granted by the court, or whether it can be reduced, or what are the circumstances under which it can be reduced, or when the appraisal is made and the amount claimed is much more than what is payable, then the amount which is determined alone will be paid and not the amount that is claimed. Suppose you suffer a damage of 2 lakhs alone, but you make a claim for 10 lakhs. On appraisal and on inspection or on inquiries, it is found that the damage suffered is only 2 lakhs and not 10 lakhs. Only 2 lakhs becomes payable to you. But the contract of indemnity is, to put it in short, the object of indemnity is to put a person back in the same position what he would have been had he not suffered the loss, had he not suffered the damage, had he not suffered the deterioration. And I told you also, as far as policy of insurance is concerned, it is of two types. As far as vehicle I'm talking about, one is called the third-party insurance, and another is called the comprehensive insurance. As far as third-party insurance is concerned, the vehicle owner does not get any compensation, but the person who suffers the accident as a result of the accident, he is paid the compensation. But as far as comprehensive insurance is concerned, the entire loss, entire damage, entire deterioration after appraisal, which is found due and payable, will have to be paid by the indemnifier, whether he likes it or not, except the electronic parts which are there, the insurance company does not make that payment. So, in short, to say, though the indemnity clause is there, the condition in which the indemnity clause applies is there must be actual damage, there must be actual loss, and you must be put back in the same position which you were prior to the loss or damage occurring. And only unless there is a loss, unless there is a damage, unless there is an appraisal, the compensation does not become payable by the indemnifier. Then we discuss some cases also on that aspect. The question is, to put it in short, the liability of the indemnifier is absolute, subject to certain limitations, subject to certain restrictions, and subject to certain conditions being fulfilled. And we also discussed saying that the indemnifier cannot reduce the compensation unilaterally without appraisal, or the insurer cannot make a secret profit over the bargain, or vice versa. The insured also cannot make a secret profit and make indemnity an object of ridicule. Here we also discuss what is called fidelity insurance that was previously resorted to by the State Bank of Hyderabad, where the fidelity or where the honesty or integrity of the cash officer is tested, and the bank pays the premium, takes a policy called fidelity insurance in case of any embezzlement, in case of any misappropriation, in case of any breach of trust, in case of any cheating. The policy is invoked, and the insurance company makes good the loss. But in turn, what the insurance company does is it joins with the bank and files a suit and then recovers that money which it has paid due to the fraud committed by the employee. Then we also said, unless there's a loss, unless there's a damage, unless there's a deterioration, the question of indemnity clause cannot be invoked. And the indemnifier also cannot make a secret profit over the bargain. I also gave an example where there was a triumvirate agreement between the consignee, and the consignee and the carrier, whereby certain goods were to be transported from Chhattisgarh to Hyderabad. On the way, the truck met with an accident, and the truck was carrying about 20 drums of chemicals to be transported and delivered at Hyderabad. It so happened that the carrier was very, very responsible. He lodged a police complaint, and an FIR was registered, Panchanama was conducted, and then the matter was reported to the insurance company along with the accident report, FIR, and the Panchanama. And, and a claim was made by the consignee for the damage to the goods. In the first appraisal, the carrier was present, and it was found at the time of inspection that only 4 drums were damaged and 16 drums were intact. And the first appraisal report said only for 4 drums the damages can be claimed. Again, what happened was the insurance company, in collusion with the consignee, conducted a second appraisal whereby the carrier was absent at that time, and then it was the insurance company paid the compensation for the entire 20 drums. Ultimately, the insurance company brought an action for subrogation against the joining along with the consignee and making the carrier liable for the loss. But the carrier took a plea. Sir, at the time of first appraisal, the question is only 4 drums were damaged and 60 drums were intact. And that was the report. And the second appraisal, which was done behind my back, has observed that 20 drums were damaged, which is not true. And seeing the record, seeing the Panchanama, everything, the stand taken by the carrier was found correct. And then what happened was the court decreed the suit partly only for the 4 drums which were damaged, and the amount which was paid for the 16 drums by the insurance company in collusion with the consignee was negated by the court. Then the carrier took up the matter in appeal, and at the stage of appeal, the insurance company realized its mistake and said, "Sir, please pay us as any amount towards a one-time settlement." Ultimately, a claim of 14 lakhs was settled for 2.5 lakhs, which the carrier happily prepaid, and the matter was closed. What I'm trying to tell you is, even as an indemnifier, you have to take all the precautions possible. If you are the and please remember, no compromise can be entered into, no settlement can take place when the insurance company is involved. When that indemnity clause is there, without the consent of the insurance company, no compromise can be effected. No money suit can be compromised by a party without the consent of the insurance company. The insurance company's consent has to be taken in order to consider a decree, whether it's before the Lok Adalat or before a regular court. So, in other words, there should be fairness, there should be transparency between the indemnifier and the indemnity holder. Just because an indemnity has been given, it doesn't mean that you can take the indemnifier for a ride. Indemnifier will be taking all the steps possible to save his company. And if you are appearing for the insurance company, what are the steps you have to take, sir? Suppose there's a claim made in respect of an accident, you will have to find out for what purpose the vehicle was insured, whether it's a passenger vehicle, whether it's a goods vehicle, whether it's a transport vehicle, or whether it's for carrying passengers from one place to another. All these things will have to be looked into. Second thing is, the person who's driving the vehicle, is he a minor or does he possess a license? If he possesses a license, whether the license is valid or whether the policy which has been insured, whether it has been renewed from time to time, whether it's still alive. Or the next thing is, look into the accident report and try to say that the person who is claiming compensation is a wrongdoer, and the Panchanama also reveals his guilt or reveals his involvement as far as the accident is concerned. And the accident, and please remember, in some cases, the insurance company can repudiate its claim and claim for what is called indemnity. Then one more type of insurance also is there. That is what is called contracts uberime fide. UBERIMAE uberime fide. FIDEI. Contracts uberime fide. UBERIMAE fide. FIDEI. That means contracts of utmost good faith. Suppose, let us say, you want to take an insurance policy. Please remember, insurance policy is not given to all and sundry. There is a particular age limit also for an insurance policy to be taken. When you are young enough, the premium which you pay is far less than when you reach a particular age. And normally the insurance company refuses to insure a person who is above 60 to 65 years. But of course, now the Prime Minister's Yojana also is there, where senior citizens are given insurance cover by the government itself. People who are senior citizens above 70 years of age, and in case anything happens to them, the government will pay them 5 lakh of rupees. And now in courts also we have what is called group insurance, which is being undertaken. 2 lakhs hospitalization fees is paid by the insurance company towards your health. So all these things are there. The question is, when you apply for an insurance policy, it is not given on a platter. You have to be examined by the panel doctor of the insurance company, and the panel doctor asks you first, did you suffer from any viral ailment or typhoid or jaundice for the past 3 months? Whether you are hale and healthy, whether your BP is correct, whether you are having low BP or high BP, whether you are in sound state of mind, and then only when the panel doctor examines you, you have to disclose everything. If you don't disclose, you suppress certain facts, and even after that, in collusion with the doctor, if an insurance policy is granted to you, It is always open to the insurance company to take back the policy, to revoke the policy, cancel the policy, and then try to say that we are not prepared to insure you. These are all the consequences which flow out of indemnity. So please remember, whether you are appearing for an indemnity holder or whether you are appearing for the indemnifier, you have to take all precautions possible. Don't take anything for granted. Read the file properly, read the papers properly, read the documents properly, read the accident report properly, read the Panchanama properly, and then come to a proper conclusion and try to defend the cause or prosecute a cause which you have initiated in a court. So this, in short, is a contract of indemnity contained in section 124 to 126 of the Indian Contract Act. So there is one of the first species of specific contracts. Next, the twin brother of indemnity is what is called guarantee. This is contained from section 127 to 147 Indian Contract Act. I'll just define guarantee and then stop. Here, an agreement where a person, the surety, promises to fulfill or perform the promise on perform the promise or discharge the liability of a third person in case of his default or where he agrees to pay a debt or perform a duty in the event that the original party fails to do so. The party who are here. So here, it's a tripartite transaction. It's a transaction between the creditor, the debtor, and the guarantor. Creditor is the person who is the lender of money. Debtor is a person who is indebted to the creditor, or he borrows some money from the creditor and is indebted to the creditor to some extent. And a third person who says that I will perform the obligations, I will pay the money. In case of default on the part of the principal debtor, I shall stand guarantee అంటే నేను హామీ ఇస్తున్నాను. That is, the question is, I stand guarantee, I stand proof to say that in case the debtor does not pay, I shall make the payment, or in case the debtor does not perform his obligations, I shall perform the obligations on his behalf. It is called a contract of guarantee. The person who lends the money is called the creditor. The person to whom the money is lent is called the principal debtor. And the person, the question is, the person who ensures payment or ensures performance in case of default by the debtor is called the surety or is called the guarantor. And all the three people enter into a triumvirate agreement called a contract of guarantee. The guarantor executes the document in favor of the creditor by saying, sir, I stand surety or I stand guarantee, I shall perform the obligations on behalf of the principal debtor. If he does not do so, if he fails to do so, if he omits to do so, or I shall perform that obligation which the debtor is due under the contract to you, I shall perform it. Then it is called a contract of guarantee. And the person who has lent the money or to whom the obligation has to be made is called the creditor. The person who is obligated to do that obligation is called the debtor, and the person who comes in between and says, in case the principal debtor does not make the payment or does not honor the commitment or does not perform the contract, I shall stand surety, I shall stand guarantee, I shall pay the money, I shall perform the obligations, is called a guarantor. And the transaction is called a contract of guarantee, and is normally succeeded by what is called a guarantee agreement entered into by the guarantor in favor of the creditor. Here, in this regard, I would like to make a mention, sir. Actually, in money transactions, normally we have a printed promissory note. Normally, the transactions are done through promissory notes only. If you see a printed promissory note, it comprises of two parts. One is called a receipt on this side, and one is called a promissory note. It is dated, so on and so forth. And the promissory note, normally, all of you know, it is payable on demand, oblique order. And the person who executes the promissory note is called the promisor or is called the debtor. And the person in whose favor it is executed is called the promisee or is called the creditor. And it is for a liquidated sum of money which is due and payable by the debtor to the creditor. Then on the other side, you have what is called a receipt. Then the question often arises, sir, which is first? Whether receipt is first or promissory note is first. Please remember, డబ్బులు పుచ్చుకున్న తర్వాత నాకు డబ్బులు రొక్కము నాకు ముట్టినదని చెప్పి వాడు రిసీట్ రాసిస్తారు. ఆ రిసీట్ is a proof of having received the consideration. Who executes the receipt? The receipt is executed by the promisor in whose favor? In favor of the promisee, stating what? That he has received a particular sum of money towards hand loan on a particular date at a particular time. The date is put and revenue stamp also is put down, and the recipient or the debtor or the promisor signs on the receipt. But after executing the receipt, he promises to repay the money on demand or order of the promisee with interest or without interest, whatever it may be. Then beneath it, you have the revenue stamps are fixed, and then on that, the debtor or the promisor signs. You may have witnesses or you may not have witnesses. Witnesses are absolutely not mandatory. But one thing you have to guard yourself against is, in a printed promissory note, normally you have one more column down, surety or security. Please remember, you shall not fill up that security column. If you fill up that security column, then the question is, it becomes a bond and you have to pay stamp duty at the rate of 3% per 100. That 3 into 3 rupees per 100 means 30 rupees per 1,000, so on and so forth. But in case you don't pay, the court will impound it and collect 10 times the amount which is due towards duty and penalty. This is what is called a simple promissory note and receipt. But what the banker does is, banker styles it in the form of a DP note or what is called a demand promissory note. Demand promissory note is, it is only one side, sir. It doesn't have a receipt. It says on demand, I, that is my borrower, son of so-and-so, resident of so-and-so, do promise to pay Mr. X, who is the guarantor, son of so-and-so, resident of so-and-so, a sum of rupees 50 lakhs, 50 lakhs towards the loan transaction. Then he signs. Who signs? Principal debtor signs. Then please remember, when we were discussing the Negotiable Instruments Act, a promissory note is also under Section 4, which is payable on demand or order, is also a negotiable instrument. That is, it can be transferred from one person to another. Then what the guarantor does is, on the reverse of the promissory note, I so-and-so, so-and-so, son of so-and-so, do hereby endorse this promissory note in favor, this DP note in favor of the State Bank of India, Nacharam branch. Then he puts his signature. Here what happens is, please note the liability. The debtor is liable to the guarantor, and the debtor and guarantor, through that endorsement on the reverse, making it over to the bank by way of assignment, all the two get become jointly and severally liable to pay the creditor, and that's how it is called a demand promissory note. But please bear one thing in mind, that receipt may be unstamped, receipt may not have a stamp, but as far as a promissory note is concerned, it should have a proper revenue stamps. An unstamped promissory note is not enforceable in a court of law. But as far as receipt is concerned, you can always pay the duty and penalty and get it regularized. Are you able to understand, please? The rest of it, we shall deal with it in the next class, that is tomorrow. So we have finished the law of indemnity. There is from section 124 to 126, and we have started the law of guarantee, which is the twin brother of indemnity. That is from section 127 to 147. After that, we go to section the law of bailment from 148 to 170. Then 171 to 180 deals with the law of pledge or law of pawn. And after that, 181, the last chapter, called the law of agency from section 182 to the end, that is 238 law of agency we'll have to discuss. So today I've completed the law of indemnity, just made a start as far as guarantee is concerned, the various facets, various ingredients of guarantee, types of guarantee, how a guarantee is made, how a guarantee is drafted, so on and so forth. We will discuss it in the next class, that is tomorrow. Any questions, please? Yesterday, I think my admin tells me that one of the lady asked a question. But please remember, I discourage as far as asking on the chat box is concerned. Whatever doubts you have got, you kindly get it cleared in the class itself so that the others also may know about it. And they may also try to get their doubts clarified. I think some lady yesterday asked a question because we wound up at that time. I think, what's her name?
Tiwari.
That is Nokia, that is Jamuna Tiwari. Please try to put your question again, please. Nokia.
It's not that.
Mr. Vasantrao, any questions, please? Not there. Okay, ma'am. Any questions? My admin will address you. That is, we are having.
Yes, sir.
Yes, sir. Please go ahead, Mr. Yes, sir.
After the long time.
Yes, sir. Yes, sir. I was not keeping well, sir. I had a virus infection.
Yes, I know, sir. It's very, very honored. Only the recovery is 3 months.
Exactly. Still, that weakness is still there, sir.
Yes. Sir, I have a query, but not for this topic.
No, you ask me. No problem, sir. I'll solve it. Please ask.
Sir, when can I file? When can we file a special wakalat for an entity?
Special wakalat. Special wakalat.
Yes,
Offering wakalat.
Offering wakalat, you can file a memo.
yes, sir. Yes.
Yes, you can file a memo, but please remember you cannot dispense with that payment of your 100 rupees welfare stamp. You'll have to affix 100 rupees welfare stamp. But the question is, on the next date of hearing, the wakalat has to be filed under any circumstances. And even in criminal matters, when you file the memo of appearance, there also 100 rupees stamp has to be affixed. But on the next date of hearing, the MOA has to be filed.
He is asking, sir, if you have a confidence on the client, that he will appear for the next occasion,
Special wakalat.
you can give a offering wakalat with a memo saying that client is out of station. He has given this. Next occasion, I will put a normal and I will get back to you. You can say that.
But as far as avoid filing special wakalat, sir, because if your client absconds, for all practical purposes, you will be made responsible.
Yes.
Right? Any more questions, please?
Thank you.
Yes.
Any more questions for today? Any specific questions? You can throw your questions. We are here to sort out your questions. All right. We wind up for today. See you tomorrow again. The same topic. Thank you. Thank you, one and all. Ma'am?